Good morning, I'm Gary DeWaal, and this is Bridging the Week for January 18th to 22nd, and today is January 25th, 2016. There was little international regulatory activity involving the financial services industry last week. The chairman of the Commodity Futures Trading Commission discussed his 2016 priorities at an industry gathering of lawyers, and one big surprise was that position limits were barely mentioned. In Canada, regulators proposed collateral protection rules for OTC derivatives. Back in the United States, it was the CFTC itself that received a qualified opinion by an accounting firm regarding its fiscal years 2014 and 2015 financial statements, and a finding that it had material inadequacy in internal controls. New York City and Washington, D.C. are still digging out of a massive weekend blizzard today, so before I go out and trudge through the snow, let's get started. Kraft Food Group and Mondelez Global requested permission from the federal court hearing the enforcement action by the Commodity Futures Trading Commission against them for alleged manipulation to have a federal appeals court rule on two of the commission's central legal theories. These are whether, quote, a defendant's large futures position coupled with an alleged intent to affect market prices, but absent any other false communication to the market, and the quote, is prohibited false signaling and manipulation, and whether the prices that result following a defendant's purchases of futures positions in a market that cause futures and cash prices to converge are artificial prices. Defendants claim that an appellate court's determination of these questions at this time would assist the court hearing the CFTC action to, quote-unquote, properly determine certain of defendants' pretrial motions and to assure that jurors receive proper instructions at trial. In April 2015, the CFTC filed a lawsuit against defendants claiming that wheat futures trades they entered on the Chicago Board of Trade for the alleged purpose of hedging were in fact entered for the purpose of artificially lowering prices in the related cash market. The CFTC accused the companies of engaging in manipulation and attempted manipulation through their activities, as well as engaging in a quote-unquote manipulative or deceptive device or contrivance, in this case referred to as false signaling manipulation. The Commodity Futures Trading Commission opposed the request of 5 industry organizations to assist the federal court hearing the CFTC's pending lawsuit against Donald Wilson and DRW Investments LLC, alleging attempted manipulation in its evaluation of the correct legal standards to apply. 2 weeks ago, 5 industry organizations, CME Group, Commodity Markets Council, Futures Industry Association, Intercontinental Exchange, and Managed Futures Association, asked the court for permission to weigh in and argue that the CFTC should be required to prove, consistent with prior case law, that respondents intended to create an artificial price, one, quote, that does not reflect the legitimate forces of supply and demand, end of quote, not solely to affect price as the CFTC charged. This was necessary, said the organizations, because, quote, market participants have a right to trade in their own best interests without regard to the positions of others, as long as their trading activity does not have as its purpose the creation of artificial or distorted prices, end of quote. The CFTC said the organization's request to provide assistance should be rejected because, quote, Amici's proposed brief offers the court nothing new, end of quote, and was untimely. Timothy Massad, chairman of the Commodity Futures Trading Commission, heralded the CFTC's upgrading of the registration status of 18 swap execution facilities from temporary to permanent, and the finalizing of its margin rules for uncleared swaps as 2 of the agency's most important recent actions. He made this observation last week before the American Bar Association's Derivatives and Futures Law Committee's 2016 winter meeting. He noted that the CFTC margin rules are practically the same as similar rules adopted by other prudential regulators and very similar to international standards and rules he expected regulators in Europe and Japan soon to adopt. Mr. Massad indicated that in 2016, priorities of the CFTC included finalizing rules on algorithmic trading, as well as cybersecurity for exchanges, clearinghouses, and swap data repositories, and improving swap data reporting. Curiously, Mr. Massad did not expressly state that finalizing proposed rules on position limits was a priority, or that it was among the CFTC's 2016 objectives. Instead, towards the end of his prepared speech, he simply stated that, quote, there is a significant amount of work going on in other areas, including position limits, enforcement, and a host of other activities, end of quote. Equinox Fund Management agreed to refund investors $5.4 million plus interest and pay a fine of $400,000 to resolve charges by the Securities and Exchange Commission that, from 2004 through March 2011, it overcharged management fees and valued assets in a manner contrary to the methodology disclosed to investors. According to the SEC, during the relevant time, Equinox, an asset management firm that specializes in managed futures, promised to base management fees on net asset value, but in fact assessed fees based on notional trading value, including leverage. Moreover, said the SEC, certain of the firm's filings with it in 2010 and 2011 misstated the firm's valuation practices related to certain derivatives. Equinox is registered with the SEC as an investment advisor and is the commodity pool operator with the Commodity Futures Trading Commission. According to the SEC, it currently manages approximately $268 million. And finally, members of the Canadian Securities Administrators published their proposal to protect customer collateral in connection with the clearing of over-the-counter derivatives. Proposed requirements address the collection and mandatory segregation of customer collateral, record-keeping requirements, and restrictions on the use and investment of customer collateral. CSA's proposal also provides a framework to encourage the transfer of customer positions and collateral in the case of an intermediary's default or insolvency. Comments will be accepted by each CSA member through April 19, 2016. CSA, made up of security regulators of Canada's provinces and territories, coordinates and harmonizes capital markets regulation in Canada. As I mentioned, the CFTC itself is in the news this week, having received only a qualified opinion from an outside accounting firm on its 2014 and 2015 fiscal year financial statements, and a finding that has material weaknesses in its internal controls over its final presentation. I cover this in detail in the article version of Bridging the Week on the website. Check it out. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. As always, I'm Gary DeWaal. This is a very snowy New York City today. Until next week, have a great week and ciao.